class, we'll be discussing about the board of directors. And as you already know by now, that every company must have a board of directors. So, company must have a board of directors for what? For decision making and for the governance purpose. There'll be a lot of role that the board of directors have to play in a company. It has to be run in a particular format according to the rules and regulations established by the law. So there must be a group of people who are going to head this, and these people who are going to head the operations of the company are called the board of directors. So the board's role is to ensure, as I already mentioned, the legal compliance and to uphold the corporate governance. So the board's actions reflect the promoter's aspirations and also give weightage to the stakeholders' rights. So, companies must constitute and maintain a board of directors as per the legal provisions that is established under the Companies Act 2013. So, every company must disclose the directors' particulars through their public statutory filings. That is, who is the director, what is his whereabouts, where was he working before, what is his address, what is his qualification, what is the remuneration that is paid to him, all sort of what are the roles and responsibilities that this person as a director is going to take up in a particular company. All of these details must be disclosed by the company in its public statutory filings, and it is mandatory to do so. The obligation also extends to the accuracy and regular updating of directors' information. So, for example, if there is any change in the qualification or in the role played by the director, then that has to be updated in the director's information records. Okay, so any changes like appointment, resignation, or removal, or any other major particulars or important details that the company undergoes when it comes to the board of directors, even that must be updated in the files, and it must also be informed to the register of companies. Okay, so the board's liability is to ensure compliance with the laws. The first and foremost duty of the board of directors is that they have to comply with the rules and regulations that has been established while running a company, to run a company. Okay, so the government had made the rules, and there are certain rules and regulations that has been clearly prescribed, mentioned, and the role and the duty of the board of directors is to make sure that they are following all these rules and regulations, to keep a check, to keep an eye that none of the rules and regulations or any of the legal aspects is not violated or ignored. So the board articulates the company's corporate governance structure according to the rules and regulations and the provisions given by the law. The board of directors is going to articulate. What is articulation? Means planning or designing the corporate governance of a country as to how this particular company has to run, in what fashion, in what particular format, and what should be the restrictions, the rules, the internal, the articles of association, how it must be done, and how should it be, if they are aiming to expand, it should be done in a particular manner, because you cannot ignore any law or violate any law, because your license will be cancelled if the board of directors doesn't pay attention to these details. And keeping the laws and regulations in mind, they are going to articulate or frame certain methods in which the company has to operate, and that is what their major duty is. So the board's action represents the promoter's aspirations, which I already mentioned. So whoever is the owners of this particular company, whoever has funded and started this company, obviously they'll have certain aspirations as to what the company should actually be doing as its major function. So that not only that is kept in mind, that is the promoter's aspiration or the person who have the owner's aspirations are not only kept in mind, but it is also the duty of the board of directors to act and to safeguard the rights of the stakeholders. Because without guarding the rights of the stakeholders, it is very hard for the board of directors to run the company, because there will be no company if the rights of the stakeholders are not prioritized. So, not only promoting your own wishes through the company or the corporate governance, but also safeguarding the stakeholders' right is the major agenda of the board of directors, and it's the main function of these directors. So they also look into accurate and up to date directors information, which has to be submitted to the register of the companies, and it is mandatory, as I already mentioned. So moving on, what is the minimum and maximum number of directors that a company can have according to the Companies Act 2013? So according to the Companies Act 2013, which is the primary regulation which governs all the companies in India, there are certain requirements and there are certain provisions which talks or deals with the number of directors that has to be appointed in a company. And here are certain key points. That is, in a public company. That is, what is a public company? A state-owned company, a government-owned company. It's called a public company. So, if it is a public company, then the minimum number of directors must be 3. And the maximum number of directors must be 15. Next, when it comes to a private company, the rules change slightly. That is, in a private company, the minimum number of directors is only 2, and the maximum number of directors can be any number, because the board is going to decide according to their requirements. The board of the private company is going to decide what should be the limit. They may decide upon 20 directors or 25 directors or even 30 directors for that matter. Okay, what happens if there is if it is a one person company? If there's only one person in the company, in such cases, the minimum number of directors is one person, and that individual who is a sole member of the company. Plus, the maximum number of directors is not specified in the law. So, you can have more than 3 or 4 or 10, depending on the requirements of that particular company. You are going to decide this. So, the minimum number for public company is 3 and maximum number is of the directors is 15. At the same time, for a private company, the minimum number is 2 and the maximum number is not prescribed in the law. So they can have as many as directors as they want, depending on the requirements of the corporate governance in their particular company. So if it's a one person company, there should be at least one person, and the maximum number is not mentioned. So it is important to note that the Companies Act allows for increasing the maximum number of directors beyond 15 in public companies through special resolution passed by the company. So what happens in a public company? You need to have more than 15 directors. What happens then? You have to call a special meeting. That is where when you call the meeting, a special resolution has to be passed by the company, where all the maximum number of the members are going to sign for the expansion of the directors beyond 15. So when you can have, what is the maximum number of the directors in the public company? It is 15. But what happens if you want to expand? You can expand the number by passing a special resolution in a meeting. Okay. So additionally, there are certain specific requirements for the appointment of the independent directors and women directors on the board of certain classes of companies. So in certain classes of companies, the law also specifically tells that there must be an independent director and a women director, because there's also an what do you say, an attempt to give role for women to be in the higher governance arena. So there are certain companies where it is mandatory for them to have one independent director who is not at all connected with the activities or the other sort of dealings with the companies, and he's completely independent person. He's a third party got from somewhere else and put there as a board member, so that he gives his independent perspectives, his independent views about the company, and how it has to be gowned and how it has to be regulated as a company. So that person is called an independent director. At the same time, when a woman is appointed as a director, that is called a women director. So there are certain companies where the law mandates, makes it compulsory for those companies to have an independent director and a women director. Okay, for instance, every listed public company is required to have at least 1/3 of the total number of directors as independent director. So 1/3, if it is a listed public company, if a company is falling under the category of listed public company, then it is their duty to have at least 1/3 of the total number of the directors as their independent directors. Similarly, every listed company and every other public company with paid up share capital of rupees 100 crores or more, or if their turnover is 300 crores or more, is required to have at least one women director on the board. So if your company is a public listed company, then you need to have at least 1/3 members, or must be independent directors. And if you have a paid up capital of 100 crores, or if you are making 300 crores turnover in a year, then you are supposed to have at least one women director on board. Okay, this is made so that they can bring in different perspective into the corporate governance, different way of thinking, women's perspective, her way of thinking, and her expertise is brought into the corporate governance. That is, and also to make a equal opportunity, to create equal opportunity to for women to hold high positions in the corporate governance. That is the whole idea of making this law. And similarly, when they are making independent directors compulsory, that is to bring in independent perspective, not being influenced by any of the other directors or the owners or the workers. He is an independent person, so he is not connected or doesn't know anyone else. He is going to give his perspective independently, and such independent views will be precious, because he is giving truthful insight into the operations of the company, and he is going to make suggestions unbiasedly. So that is the whole idea of having independent directors. Okay, so these provisions aim to ensure adequate representation, oversight, and independent decision making in the governance of the company. That too particularly in larger and listed companies. Okay. So moving on, we have the appointment, removal, and resignation of the directors. So how is the appointment of directors is done under the Indian Companies Act? And how they are removed, or how can they be removed, or what is the method of them resigning from their job. So the Indian Companies Act 2013 provides detailed provisions regarding the appointment, removal, and resignation of the directors in a company. So some of the key points are that appointment of the director, that is the first director of the company, are typically named in the Articles of Association, AOA. This is a very major document, as you already know, which talks about the incorporation of the company itself. So after drafting or putting this document in place, only then the company, and getting it registered with the register of companies, only then the company will be registered and it comes to existence. Okay, so at that time itself, you should have mentioned at least one person as your director in the Articles of Association. That is done at the time of incorporation itself. Next is the subsequent directors. That is the appointment that is made by the board. The board of directors can appoint additional directors. So you will not be knowing, when you are incorporating a company, you will not be knowing how many directors you might need. So at that time you will be mentioning one of them, but later on, as you start operating as a company, you can take in more directors as per the requirements of the company. Okay, so they can have more or additional directors, or fill casual vacancies as directors also, subject to the again approval of the shareholders at the next general meeting. So general meeting includes the shareholders perspective also. When they are calling for a general meeting, it's not only the board of directors but the shareholders also sit in the meeting. So you have to take the permission of the shareholder before appointing the additional directors. You can't do it according to your wish or whims and fancies. You have to take the approval of the shareholders in the annual general meeting. So next is appointment of the shareholders. So shareholders can appoint the directors in the annual general meeting. Okay, either you the board makes the appointment and or suggests the name and take the approval of the shareholders, or the shareholders themselves can actually appoint the appoint the directors as per their own decision, that will be which is approved in the annual general meeting. Okay, that is the AGM, or through even postal ballot. If you're not able to come to that place of meeting, you can make it your oath through postal ballot, writing the person's name and voting it or posting it to that particular place of meeting, so they receive your consent and they can go ahead with the appointment of that particular director. Next is the independent directors, which we already discussed. That is, every listed company and certain other classes of public companies must have at least 1/3 of the total number of directors as independent directors. Okay, they have to be appointed in a particular specific procedure, has to be followed when they are appointed according to the law. Okay, so as already mentioned again, the women directors and every listed company and other prescribed companies are required to have at least one women director on the board. Next comes the removal of the directors. Can directors be removed from their positions? Yes, of course. So, removal by the shareholders. The shareholders have the right to remove any director before the expiry of their term by passing an ordinary resolution at a general meeting. So, they can pass an ordinary resolution and terminate the vacancy of a particular director in the annual general meeting or in any general meeting conducted. Okay, after giving the director a fair opportunity to be heard. Sometimes what happens, directors will be involved in illegal activities like using the funds for misappropriation of the funds, or misusing the funds, or misusing the position that they are holding. So in such cases, what happens in bank frauds and all, so this becomes an issue. So when you can remove the directors if they have such history. So after hearing to them, after giving them a adequate time and chance to report themselves or to talk to them, you can actually terminate them from their position, okay, by ordinary resolution in a general meeting. That is done by the shareholders. Next, it can also be removed. The directors can also be removed by the government itself. So the central government can remove a director on certain grounds such as fraud, persistent negligence, or mismanagement of the company. Because it's just not mismanagement or negligence, thousands of workers' lives will be at stake, and there is crores of rupees that will be put on the put at the risk. So the stakeholders money is at risk, and employees work is at risk, and the whole company may shut down because of this negligence and mismanagement. So to avoid that, the central government can step in and terminate a director from his position. Next is removal of the director by the company law tribunal. I hope you already know by now what is a tribunal. Tribunal is a quasi-judicial body which comprises not only of the judges but also experts in the company law matters. They can be ex-officers or administrative personnel who are expert in this particular company law, and they will also sit in the tribunal. So that quasi-judicial body, where it also comprises non-law people. Judges are completely law people. So when it comprises also non-law people who are executives, who are ex-COOs, CEOs, administrators in the company, and or the government officials who have been retired from their positions and have been involved in the maintenance of the company law, in such cases even they can be taken on board with the National Law Tribunal, and that is called a tribunal. It's a quasi-judicial body, that is semi-judicial body, not completely judicial in nature. Okay, even the company law tribunal has the right to remove a director on specific grounds, and the specific grounds are very common, which you already know, that is the abuse of the position, committing fraud, oppression of the minority shareholders. All shareholders has to be treated equally, and if there's any sort of that comes under the mismanagement of the company, right? So in any such cases, they can be removed. And next comes the resignation of the directors. Can they voluntarily resign? Of course, yes. The directors, because they have certain issues, it may be health issues or personal issues or family issues, and if they're not able to give enough attention to their work and to their company, they are free to resign from their position, but they have to give a prior notice in writing to the company, so that the company will start making arrangement to replace this particular person. Next is resignation by operation of law. In certain circumstances, what happens, a director may be deemed to have resigned from the operation of law, such as disqualification, insolvency, merger acquisitions, absence from the board meetings, or for a illness due to prolonged period. In these things, what happens, he is pushed to resign on his own, because the operation of law is not properly happening through him. So what happens, he's either disqualified, so he's pushed to resign, he's insolvent, he's pushed to resign, and is absent from the board meetings, because his first duty is to attend all the board meetings. If you're not going to attend the board meetings, how will you operate the company efficiently? Not possible. So it is his duty, and if he is failing to perform his duty as a director, he can be asked to resign. Or if he is suffering from prolonged illness and it is not getting cured, no one can help but give him, ask him to resign from the position. And next is the disclosure requirements. The resignation of the director and the reasons for resignation must be disclosed to the registrar of the companies. So the registrar of the companies is an executive body who functions for the Ministry of Corporate Affairs. Okay, so it is established under the Ministry of Corporate Affairs, that is the central government ministry. So after a person resigns from his directorship as a director, that must be informed to the registrar of the companies in the next company's board report. Okay, it is a duty of the next person who is taking in charge to make sure that this information of this particular director resigning, that is put in the papers and it is submitted to the registrar of companies. Okay, so whatever the company does, it is a duty of the company to inform the registrar of companies with proper paperwork and evidential requirements. Okay, the Companies Act also provides for certain procedural requirements. That is, you have to fill the form, notices, disclosures that is related to the appointment of the directors, removal of the directors, or resignation of the directors. In whatever cases, there will be certain forms, certain notices, certain disclosures that the company has to fill and oblige with the required legal methods. That is made to ensure transparency and to comply with the existing legal provisions. Okay. Next is, what is the age limit for directors? Can a 100-year-old person be brought on board as director? Yeah, of course, he has more experience than a 50-year-old. But can he be bought? Is there any law that talks about the age limit of the directors? Certainly, yes. So the Companies Act 2013 does not exactly prescribe a specific age limit for the directors in the companies. However, there is certain thing that it talks about the age limit for the directors. Okay, so there is no minimum age limit that is prescribed for the appointment of the director in a company under the Companies Act 2013. So they doesn't say, or the Companies Act doesn't tell you anywhere or prescribe any age limit that a person becoming a director must be 35 years of age. No, it is not told anywhere. Okay, so a 20-year-old can also be the director of the company. It is very common, in the situation where the father is the owner of the company, his children will be, even though they are just young adults, they'll be incorporated as the directors of the company, and they'll personally involve in the operations of the company. Next, as per section 196 clause 3 of the Companies Act 2013, the maximum age limit for managing director, whole time director, manager is 70 years. So the last age or the maximum age in which a person can be appointed as a director in a company is 70 years. And can they extend this? Yes, they can, unless the appointment is approved by special resolution passed by the company in the general meeting. So, what is the age limit for the independent directors? The SEBI regulations 2015 prescribe that no person after attaining the age of 75 years can be appointed or continue as an independent director in a listed company unless approved by the special resolution of the shareholders. So, SEBI tells Companies Act 2013 says 70 years, but with special resolution you can expand that age limit. And again, SEBI regulation 2015 says no person must be appointed who is above 75 years of age as director, but again that can be extended, or the leverage can be taken by passing a special resolution of shareholders. The point is, if shareholders approve, anything can be done in a company, or anything is approved in a company, okay, except it should not be illegal. And next is the age limit for the resident director. We didn't discuss about the resident director. Resident director is no one but is a person who is residing in India. And how long he should be residing in India? He must be in India or in this particular country for at least 182 days in the previous calendar year. Only then he is considered as a resident director, and there must be at least one resident director in every company. Okay, so there is no specific age limit prescribed for the resident director. While there is no general age limit for directors, the Companies Act and other regulations do impose certain age related restrictions. As we already know, one is 70 and one is 75, but both of them can be expanded or extended to more years with the help of or with the permission of the stakeholders by passing a special resolution. So restrictions particularly for managing directors, whole-time directors, managers and independent directors in a listed companies, and these provisions are aimed at ensuring effective governance, because how much productive can a person above 75 years can be is the question. If he's hale and healthy, and if he can manage the company affairs very well, and he can think with a straight mind, then why not can he be the director for some more years? So, but in case if he is not capable, then he must not be there, because he cannot deliver for the corporate governance effectively, and his decision making cannot be competitive. So in such cases they have to reconsider the decision. Next is independent directors, which we already discussed. They play a very crucial role in ensuring the good corporate governance, and they also are appointed basically and importantly to protect the interest of the stakeholders, okay, and especially the minor stakeholders in the companies. So Companies Act and the SEBI regulations 2015 have laid down specific provisions regarding independent directors, and they are, as we already know, the first one is the definition. The independent director is a non-executive director who is not taking any remuneration as director and does not have any relationship or transaction with the company or its promoters, investors, management, or its sister companies or the subsidiaries. So there is no way his judgment or his decision making can be influenced. So that is the whole idea of appointing a independent director. He is independent from all the influences. That is how he can bring in the independent perspective. Freely he can speak the company's positives, the pros and cons, the dangers that the company is getting into, and his perspectives will be given more priority because he brings in the independent perspective without being influenced by other causes. Okay. Next, appointment. Every listed company that is, and it is certain other prescribed classes of public companies are required to have at least 1/3 of the total member of directors as independent directors, and the tenure is for 5 consecutive years. How long should he can be a independent director in a company? For 5 continuous years. Okay, and he can be reappointed for the next term too. Again, there must be a special resolution that has to be passed by the company, and disclosure of such board appointment must be made in the board report and given to Register of Companies. Next is the eligibility criteria. So SEBI regulations and the Companies Act also specify certain criteria for determining the independence of the director, that such not being a promoter or an employee of the company. He cannot be a promoter of the company, he cannot be an employer of the company, and not having any sort of other pecuniary relationships with the company. Financial transactions or any favorable transactions or any sort of relationship with the company he is not having. He is completely not at all related to the company at all. Only such people can be appointed as independent director as per the law. Next is the separate meetings. Independent directors are required to hold at least one meeting per year without the attendance of non-independent directors and members of the management to discuss the matters pertaining to company's affairs. So there should not be directors, there should not be management of the company. Only the stakeholders and the independent director is going to address or talk or involve in this particular company. And as an independent director, it is his duty to give or attend or conduct one meeting independently without involving the other board members and the management of the company. So next is performance evaluation. He is an independent director and he is expected to evaluate the entire board of directors, excluding the director being evaluated. Okay, so if he is evaluating others, then he cannot evaluate himself, but he is going to evaluate other directors. How is their work being done? How are they functioning in the company? How are they contributing to the company? What is their role? Are they doing their duties properly? If there is any whistleblowers or any suspicion in the company's accounts or in the operations, has it been taken care? Is CA doing his job? Is other directors doing their job properly? Is there any issue regarding to the production or relating to the employees? So all of these things he is going to give a independent opinion on all of these things, and he is going to evaluate it and submit a report, and that report has to be again sent to Register of Companies by the company. So liability. What is the liability of an independent director? He shall be held liable for certain omissions or commissions by the company. So he has to be very meticulous and sharp eyed, because there cannot be any omissions or any wrong things happening in the company. It may be in governance or account books or whatever it is, operations, whatever it is, there cannot be anything wrong happening in the company. That's what is said under the Companies Act and SEBI regulations. So code of conduct, yes, independent directors are required to abide with a specific code of conduct which is prescribed for the independent directors under the Companies Act and the SEBI regulations, which includes the professional conduct, roles, responsibilities, etc. So moving on, the independent directors of the board aims to bring an objective view, independent view, different perspective, impartial, unbiased opinions to the decision making process of the company. Why is this done? This is done to make sure that there is checks and balances in the operations of the company, in the management of the company, to protect the interest of the stakeholders, shareholders, especially the minor shareholders, and the overall company's governance. Okay. Moving on, we have the powers of the board of directors. What are the powers of the board of directors? So the board of directors is the governing body of a company and is vested with significant powers, which you already know. Obviously, if you're a board member of a company, then you have significant powers, but at the same time comes roles and responsibilities. Okay, there are general powers. The board of directors has the general powers to manage the governance of the company, to conduct the affairs, day-to-day affairs of the company, and to maintain and to act according to the memorandum and articles of association of the company as said under section 179 of the Companies Act. Next is borrowing powers. The board has the power to borrow funds and secure the payment of such borrowings by mortgaging or charging the company's assets. See, sometimes not every company has cash on hand. Sometimes they have to mortgage their property. They have to take loans from the banks. So every time the what shareholders cannot come, because shareholders have appointed directors to work on behalf of them. So the directors have the borrowing powers. What are they going to borrow? Borrow money from the money lenders, to banks. They have the power to mortgage the property, and they are with the they have to act with the approval of the, again, shareholders as mentioned under section 180. They cannot act independently on their own, but as per the shareholders opinions, they have to conduct a meeting and take the decision. Next, investment powers. If the company is making good money, then if they are planning to expand the company, they already have companies all around the India, and if they will have to take it to other countries, other foreign countries, they are free to do so. But again, they have to ask the shareholders as to how it should be done, how much money must be invested, and what are the other business expansion mechanisms that they are looking into, and how they are going to do it. All of this detailed plan they have to work out and take approval from the stakeholders and the shareholders. Next is the issuance of the securities. So the board has the power to issue debentures, bonds, other securities like shares and all that, subject to the approval of the shareholders. Again, whatever they do, they have to do according to the opinions of the shareholders. They have to ask the shareholders for their opinions. Next is the appointment of the key managerial person. So the board has the power to appoint and remove key managerial persons. Okay, who are the key managerial persons? That is KMPs. They are the managing directors. They are the chief executive officers. They are the chief financial officers, and they are the company secretaries. So they can appoint the key managerial personnel as per section 203 of the Companies Act. Next is the delegation of the powers. Can the board members delegate their powers? Of course, they can delegate the power to the managing director, because one person cannot take over all the work or activities in a company. So they have MDs, that is the managing directors, managers, and other principal officers of the company, who is subject to the provisions of the Companies Act and the articles of association of the company, and they are going to act accordingly and report back to board of directors. Okay. Next is the declaration of the dividend. The board has the power also to recommend the declaration of the dividend to the shareholders, and approval of the financial statement. It is the board of directors who is going to give approval to all the financial statements in the annual general meeting as per section 134 of the Companies Act. Formation of the policies. If there is any new policies that has to be adopted and adhered to under the company mechanisms or for the company's governance, then they have the power to make new laws and policies for the better management of the company, on remuneration policy, on corporate social responsibility and risk management policy, and any other policy for that matter, which is required to run the company seamlessly and efficiently. Okay. So what are the other powers? The board also has the powers relating to the allotment of the shares. How much share must be sold? How how much should be given for in-house, how much should be given for the public, those decisions will be done by them. Buyback of the shares, approval of the related party transactions, appointment of auditors, and other matters as prescribed under the Companies Act. And for all these and other things that is mentioned under the Articles of Association of a company, all these powers is given to Board of Directors, and the Board of Directors also exercises these powers collectively as a board, and individual directors do not have any specific powers unless it is delegated by the board. So the whole board of 15-20 people has to operate in the company's governance. Only because one person feels like doing something, he cannot do it on his own independently. He has to take the approval of the other board members. The exercise of these powers is subjected to the compliance of the applicable laws. So, which are the laws? The SEBI regulations, the Companies Act 2013, and apart from that, he also has to follow the internal policies, the internal rules and regulations of the company itself. So, he should not be violating any of these things. Only then he'll be considered as a good director. Okay. So, with this, we conclude this class. It was a very exciting subject that we discussed today, and please do follow, subscribe, and like this video, and I'll see you in the next video. Thank you.